हेलो एवरीवन। टुडे वी आर गोइंग टू डिस्कस अबाउट सेक्शन 4। हमने हमारी पहली वीडियो में हमने स्टार्टिंग में अर्लियर वी डिस्कस्ड अबाउट सेक्शन 1, सेक्शन 2, सेक्शन 3 एंड नाउ कमिंग ऑन टू सेक्शन 4 ऑफ इंडियन एविडेंस एक्ट। सेक्शन 4 डील्स विद मे प्रिज्यूम, शैल प्रिज्यूम एंड कंक्लूसिव प्रूफ। यहाँ पर बस ये तीन टर्म्स को अपन को डिस्कस करना है एंड देन वी आर डन फॉर द डे। सो सेक्शन 3 में यूजुअली जनरल रूल क्या होता है कि कोर्ट कभी भी किसी फैक्ट पर रिलाई करने से पहले it demands for proof. So court can rely on any fact only after it is being proved. But there are certain exceptions that in those cases, Indian Evidence Act allows the court to presume certain fact, even without calling for proofs. Court can presume certain facts. Now, this presumption of facts is divided into various categories. So there are various kinds of presumptions. In order to understand section 4, we have to understand these kinds of presumption. There is presumption of fact, presumption of law, and then there is mixed presumption. So mixed presumption includes that is the may presume, court shall presume, and conclusive proof. So that is of mixed presumption. Rest is about presumption of fact and presumption of law. So now starting with presumption of fact. Presumption of fact is basically an inference of any existence of fact which the court thinks that is likely to happen in course of events. तो यहाँ पर सपोज जैसे कि एक बहुत बेसिक एग्जांपल लेते हैं, दिन के बाद रात आती है, राइट? A night follows the day. और अपन इससे और in order to have a better clarity, we can take an example that suppose a watch of A is being stolen and later on it was found in possession of B. Then it is a natural presumption of fact that yes, this watch was stolen by B, or B has taken it from some other person who has stolen such watch from A. So this is a natural presumption of fact that अगर A की watch गुम गई है और वो B के पास मिली है, then it is a natural presumption of fact that yes, B has stolen or B has taken from someone who has stolen it from A. So this is the presumption of fact. This is because on the basis of human experience, on the basis of logical reasoning, an inference is drawn, that is of any fact which is likely to happen in course of events. All right. So this is all about presumption of fact. And it is explicitly dealt in section 114 of Indian Evidence Act. Now talking about presumption of law. Presumption of law में दो categories आ जाती हैं. पहला बोलता है irreversible presumptions of law and second is revertable presumptions of law. The word first we will discuss about irreversible presumption. So irreversible presumptions itself states that these presumptions are those which once proved cannot be proved otherwise, right? Because there is no option to rebut these presumptions. So once if any fact is proved, if any fact is presumed and the same is proved in the court, then that fact cannot be proved otherwise. So that is a rebuttable presumption. हम इसका एक एग्जांपल लेते हैं, such as in section 82 of IPC states that nothing is an offense done by a child under the 7 years of age. अब यहाँ पर जैसे ही हम ये एस्टेब्लिश कर देते हैं कि this of the said offense of murder, theft or dacoity or any offense as such is committed by a child under 7 years of age, then it is a presumption that this is not an offense, right? So this is an irrebuttable presumption that because once this is established that the child is under 7 years of age, means even if the child has committed murder, that will not be considered as an offense, and this is a presumption of law which is irrebuttable and cannot be proved otherwise. So this is all about irrebuttable presumption of law. Now talking about rebuttable presumptions of law. So rebuttable presumption means that once the facts are proved, once facts are proved as conclusive, once the facts are proved, they are conclusive unless and until they are proved otherwise. So rebuttable में यहाँ पर option होता है for the parties to rebut and to prove it otherwise, because though there is a presumption, right? Such as we say that that accused is innocent until proven guilty. So this is a rebuttable presumption. We presume that accused is innocent, but if it is proved otherwise, the accused becomes guilty. So this is how the rebuttable presumption of law works. That the presumption is that yes, the said fact is conclusive, but the said fact if is proved otherwise, then it may take the another stance. Such as the accused if proven guilty, accused is innocent until proven guilty. If proved otherwise, then it becomes guilty. So we can also take another example of the same. That is like if a child is born, if the child is born in a legal wedlock, then this is presumed that the child is a legitimate child, right? But if anyone questions the legitimacy of child, then that child then the person who questions the same has to disprove the same, has to prove it otherwise, that the child was not born in the legal wedlock. The burden is on the person who questions the legitimacy of child. So if he proves otherwise, then that would be the stand, or else the presumption is that if the child is born in the legal wedlock, then the child is a legitimate child. So these are rebuttable presumptions of law. Now coming on to the third category, that is mixed presumption of law. Now, in order, the mixed presumption of law, Indian Evidence Act basically states in its various sections that the court may presume this fact, the court shall presume this fact. So when these words are used, the may presume or shall presume, now we have to understand about these two words. And when the court may either, Indian Evidence Act either may use these words in combination, that is known as mixed presumption, or it may specifically state use any of them, that is as a presumption, a court shall presume, or it may state that, or any section may state that court may presume. So if these words are used, then how are they interpreted? So in order to understand this, we will differentiate between court may presume and court shall presume, right? So may presume are kind of discretionary in nature, where the court has discretion to presume a fact or not to presume a fact. Court may either call a party to prove the fact, or may presume a fact without calling a party to prove the same. Here there is kind of discretion on the court where the words used are court may presume, but where the words used are court shall presume. In that case, it is basically a legislative command on the court to raise a presumption of fact as proved, unless and otherwise it is disproved. Here there is no discretion left on the court. It is mandatory for the court to presume the said fact until and unless it is disproved, right? As we understood in the case of like legal wedlock, the legitimacy case, wherein in the legitimacy example that the child is born out in the legal wedlock, then it is considered as a legitimate child until and unless the same is disproved by the person who questions the person who questions the legitimacy of child. If he disproves the same, then only the fact would be the stance of the fact would be changed, or else it is a presumption that the facts are conclusive until unless they are disproved. So this presumption is a mandatory one for the court. They have to presume this, but where the may is used, the court has the discretion. So this is all about may presume and shall presume. Now coming on to the conclusive proof. When we talk about conclusive proof, wherever it is mentioned that the said fact or the said statement is a conclusive proof, that means now the court does not have any discretion to either call a party to prove the same or call a party to disprove the same. Nothing can be done. This is conclusive and is binding, and it does not have any it is binding, and its validity cannot be questioned by either of the party. So we can understand this again from an example. Suppose if A has filed a suit in court to declare that B is the legal wife of A, right? Now if court, after entire analysis and discussions, after entire adjudication, court declares that yes, B is the legal wife of A. Now later on, this B files a suit against D for claiming the property of C by stating that by claiming that she is a widow of C. Alright, so now the case has been filed by B against D for property of C, and by claiming that she is the widow of C. So now in this case, since the case was filed by B against D for the property, so now D can, if D places the copy of the judgment which declared that B is the legal wife of A and not of C, then that judgment is the conclusive proof to state that yes, B is the legal wife of A and not a widow of C, and hence B is not entitled to file a suit for property against D because B is a legal wife of A as declared by the court as per the judgment. So if the above copy of judgment is filed, then that would act as a conclusive proof. So if this conclusive proof is placed upon, then no party is allowed to prove or disprove this statement or this judgment, because it is a conclusive proof and is binding and would decide the entire case. So that is the power of conclusive proof. Now this includes entire mixed presumption. Mixed presumption includes may presume, shall presume, and conclusive proof. Presumption of law includes rebuttable presumptions, irreversible presumptions, and presumption of fact is basically about the logical reasoning. Now, in order to have a better clarity, we will understand the differentiation between presumption of fact and presumption of law. Presumption of fact is basically based on logic, human experience, and law of nature. Whereas in case of presumption of law, it is based on provisions of law. Because if a law states, as we understood under section 82 of IPC, that no person shall be liable for any offense if the offense was committed by a child under 7 years of age. All right. So that is based on provisions of law. Additionally, presumptions of fact are discretionary in nature. They are usually uncertain. Whereas in case of presumptions of law, they are mandatory in nature and are more uniform. That's it about today. And we discussed about section 4, that is the may presume, shall presume, and conclusive proof. We discussed it in detail. Now, if there are any doubts, you guys can mention in the comment box. And if you like the video, then you can share, comment, and please subscribe the channel. Thank you.